You're all very welcome. Welcome to our program this afternoon. Advertised time is 3:30, so in 4 minutes we will start. In the meantime, we'll share a little bit about the Association of Ghana's Elders. We're just going to share a few basics about us before we get started. Thank you. Once again, you're very welcome to the program organized by the Association of Ghana's Elders. And we're going to share a few things about the organization as we wait to get started at our scheduled time. Thank you. Thanks a lot for coming early. Thank you. You're very welcome. Take a seat. So wherever you are, if you're home, take a seat and then join us as we begin our program shortly. So this tells you a little bit about AGE, the Association of Ghana's Elders, about the work we look to do and are doing in the areas of advocacy, working with organizations and individuals. Okay. So if you are encountering AGE for the first time, this tells you a little bit about who we are and what we do. You're very welcome. I see our members trickling in. Thank you for coming in early. And welcome, 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 welcome. It's 3:30. We advertised and said we would start at 3:30. And so we're going to carry on, share a little bit more about AGE, and then we'll start with our resource people. Thank you. So the three key areas in which we actively work or look to work: advocacy, programs, and then events, like what we're holding today. And this is how we engage those who are interested in supporting us. These are some of our partners who currently offer discount services and products for some of our members. And so if you're a member and you have an age card, membership card, once you engage with any of these organizations, they would be more than happy to share products that they've tailored also to your benefit. And these are partners we hope to engage. Some we have already engaged and have a relationship with. Some we are looking to engage. And so it would be great if you're connected to any of the organizations on the screen to help us reach out to them. There's a lot that we look to do as an organization. And this is one of our big dreams, big dream, something that we hope to do. And we might tell you a little bit more about this later on. Evergreen housing communities, so not old people's homes the way people see them, but communities for mixed populations. We'll talk about that later on. And by the time we're done with this session, if you're not an age member, please do join us. And any of us on the call will be more than happy to take your information, reach out, and share a little bit more about age. A few things that we've done in the past. We had a career workshop for seniors. We had a forum, a stakeholders forum. This was in 2017. We visit different groups of retirees. This is the retired seafarers at the Mariners Club in Tema. We spend time we work with other organizations, including the Center for Aging Studies at the University of Ghana. Each year, up until last year, we've joined the AIM, that's the Accra International Marathon. And some of you may recognize yourselves on here, where we walk for 5 kilometers and then at the end of it, hang out with some young people. So we do visit different groups. So if you're on this call and you have a group of seniors, your peers, old boys and girls group, that let us know, and we'll be more than happy to join you for any of your meetings. This is one of my favorites, showing a lot of different activities that we engaged in. And thanks to a little support from the Ministry of Finance, we were able to send some support items to seniors in the heart of the last year's season of the pandemic. And we've been organizing virtual hangouts, and this is one of many more to come. So thank you very much for giving us the attention. We shall get started in earnest with me turning my video on for starters. Okay. All right, so you're very welcome. My name is Esi Ansah. You're very welcome to today's program. And as part of this program, we're going to have resource persons who've already joined us. And we're going to have them respond to questions that you have sent to us already. So thank you very much. And as we carry on, we're going to open the floor. We know that there are many questions that people have shared already. And so we will open the floor for your questions. And so we're rolling along. We've already gotten ourselves started. My name again is Esi Ansah, and I set up AGE in 2013, and we've been running since. And we thank God that He's kept us. It's been a rough year, a rough last year especially, but we're thankful that God has kept us healthy and alive, and here we are. And it's time to engage again and begin to talk about issues that are really important to all of us. And this topic was prompted by a need because we have observed that a lot happens when someone passes. And there are many young people who feel that a will, that's something for older people to worry about. Also, we have older people and just people in a cultural context generally who feel that it's too morbid to talk about wills, etc., and so have remained relatively silent and unwilling to discuss issues around having a will, issues around death. But in the last few years of losing young people, older people into different things, we realized that it's important. We need to have this conversation. And so I'm glad that you've made it. And we would want to start with a few questions. And so that will help to shape the conversation. And so if you have questions, you may put them in the chat box. If you click on your name, you'll find, if you click on your name, the three dots, you find the chat section or at the bottom of your screen. And there you can share your questions with us so that our resource people can harvest those questions and then we can continue with them. So once again, thank you very much. You're very welcome. And I'm going to introduce our resource person in 2 minutes so that we can get started. And so if you have any questions, you may also unmute yourself and share it. And we're tracking all the questions. So you may unmute yourself and share your question, or you may type it in the chat box within the next 2 minutes before our resource persons take over the conversation. So if you have any questions to share, thank you very much. And perhaps I can share some of the questions that have come to us so far. One says, any guidance in the actual preparation of the will itself? Can I draft my will without a lawyer? Another question says, what type of endorsement is required for a witness and or for certifying a will? Some have asked that we share information on living wills, joint living wills. Another question says, who can be appointed as an executor if there are no family members to appoint? Another question says, what happens when I am gone and I have a bank account which I did not include in my will? How will the law treat it? Another one says, I lost my dad 5 months ago. He has no will, has 3 wives and 12 children. What can I do? We don't know your relationship to the other family members, etc., but I'm sure that some of the general guidance that our resource persons give will be able to help. And another question we just received says, what's the price range for making a will? So our resource persons will give us information, share basics on how, and the cost, etc. Thank you very much. Okay, so our resource persons, can I have you turn on your video as I also do the same? Okay. All right, so I'm going to introduce our resource persons. I'm going to start with my good friend and partner in crime, good crime, Nana Kwesi Ewa. And Nana is, we're going to ask all of you to share one lesson. Share one lesson you've picked up from a senior citizen you're close to. One lesson you've picked up from a senior citizen you're close to. What have you learned from a senior whom you know. So Nana, let me start with you, Nana Kwesi, and welcome.
Thank you very much. Is it okay if I call you Oja, or they don't know?
I guess it's already out, so yes.
Thank you, Oja. Thank you very much. It's a pleasure to join you this afternoon, and particularly Age. It's amazing the work you've been doing for Age. When you first shared with me, I willingly volunteered to help whenever I can. And so for me, this is a great opportunity once again to share knowledge and also to help our elderly in the society. I guess one of my favorite persons that I've encountered must be my grandmother. Unfortunately, she passed away, but there's one thing that she taught me, which I think has been a good guide for not only myself, but all my other cousins, that is basically her grandchildren, is that hard work never kills. Hard work never kills. This was a woman who, even in her 90s, she lived up to 99, by the way. In her 90s, you could still see her supervising construction work around the house and all of that. And she didn't let weakness or old age or her ailments deter her from continuing to work hard, even at that level. So it just shows, it was a clear testimony of the fact that hard work indeed never kills. So that's one thing that I learned from her. Thank you.
Okay, thank you. All right. And we also mentioned that we have a gentleman who's joining us, Mr. Charles Garshon, and he's worked with SSNIT for the last 19 years. And so has a lot of experience in the space of pensions and, you know, the kind of issues that are relevant to wills as well. So I'm asking him the same question. Do share with us one senior citizen you've learned from and one lesson you picked up from them. So Charles, thank you for joining us, and please go ahead.
Thank you very much for this platform for us all learn from one another. In recent years, the one that I would say I remember is a pensioner who passed on in February this year. I first met him 3 years ago, Mr. Ohene Bekwe. His level of humility at that age, and considering where he worked and the level he rose up to, was really amazing. I was compelled to virtually be visiting him twice a year because he had so much to share. And I looked at what he does, the way he relates to me. He sees me and talks to me as if I'm much older. I carry so much power. And that was very inspirational. And it taught me a lot in how to even manage my immediate team. So I'll say for me, I learned so much from the late Bekwehu, unfortunately. And I'm sure if he was to be alive, he would have been joining us. Once I tell him I'm going for any program, he simply just wants to be there. He would have joined us on this platform. And for me, that is one lesson I want to share.
Wonderful. Thank you. Thank you very much. All right. So Lady Eileen, let me come to you. Thank you so much for agreeing to join us. And you're a woman who wears many hats. And that's the one thing that our resource persons have in common. They're all doing many different things. A baker and child development, you know, practitioner. So tell us about one senior citizen whose lessons have stuck with you.
Thank you, AC. I'm glad to be part of this program. I am very happy that I'm able to contribute something small for our elderly in society. I still think we don't do much for them, but I'm glad that in my own small way, I'm able to do something small for them. So thinking about an elderly person, I thought about so many people, and then I settled on my grandfather. My grandfather has passed away, and I always think, how old would he have been? And I realized that this year he would have been 101.
Oh, wow.
Yes. What I learned from him was, one, he was extremely hardworking and extremely giving. And it taught me that in giving, we receive, because he was so generous and he had enough to give away. And I always think that he was able to have what he had because he was always giving. And that has taught me a lot, that, when you give and you give to other people in society, there is a way that you get blessed by getting more. And for me, that's the lesson I have learned from him.
Fantastic. Thank you. Thank you very, very much. All right. So on that note, we're going to plunge into our session with questions. It is 3:47 right now. So we're going to keep going for another half hour, 20 minutes to about half hour. And I'm going to ask our resource persons to keep their videos on and to be quick with their responses so we can cover a lot of ground. We've already gotten questions from participants, and we have some still coming in through the chat. And so crisp responses would be fantastic. All right, so let me start with, and I'm not sure how many of our seniors who are on the call right now are familiar with raising your hand on Zoom and all that. But if, I'm going to ask a question and ask that you raise your hand. If your video is on, you may raise your hand physically, and that's okay. And you may raise your hand electronically as well. If you once upon a time used to think wills were for old people, not for young people, and it's too morbid, raise your hand and let me see. I'm going to raise both my electronic and my physical hand. I see, Auntie, I see some hands up. Okay, so I'm not alone. I see hands going up. I'm not alone. Many people think that wills are for older people, and you should only write your will if you have a lot of property, have something to give, and wills are all about property sharing. That's the thoughts that many people have had for a long time. Tell us in the simplest term, what is a will? What is it supposed to do? On this call, we have young people in their 20s and 30s, we have people in their 70s and 80s, so we're covering a huge range. And so let's presume that not everybody on this session is familiar with wills, etc. All right, so please help us. And let me start with Nana. In the simplest terms, what's a will? What's it supposed to do? You're muted, Nana.
Okay, thank you very much. In the simplest terms, a will is a document in which you make declarations as to what should happen when you are no more in this physical world. It's as simple as that. That is what it is. So it, like you said, it doesn't only have to do with distribution of property. You can decide as to how even your funeral should take place, how you should. Some people choose to be cremated, others want to be buried at a particular cemetery, even as to where you want the funeral service to take place and all of that. You can even go ahead to decide who should be present at your funeral and who should not. And so the will gives you the opportunity to actually do that. And so in simple terms, that is what it is.
Okay, that's very helpful. Now, let me ask, are there different types of wills, or a will is just whichever document we put together? And maybe Lady Eileen can start off with that.
Basically, A will is whichever document you put together. So once it covers the instructions for what should happen when you are no more, that's your will. And then it also covers how you want your assets to be distributed.
Okay. Now, one thing that Nana said, which I found interesting, was you can lay out how you want your funeral, burial rights, all those things are, but aren't wills read, you know, way after you are gone? Or can the will be read immediately? I thought wills were, or once upon a time, I used to think wills were read a year after the person had passed. So could you clarify that for us?
You see, I have realized that in our society, we always wait to do the 1 year celebration and then we read a will. But a will takes effect as soon as the person has passed away. In fact, I have been witness to a will that was read, and in the will, the lady was stating how her burial should be done. And she had been buried for a year already.
Wow.
And so if you have these kind of provisions in your will, it's better to tell somebody, because if you don't, in our society, typically it will be read after a year.
Okay. And one of the questions that we received was also with regard to the type of will. Can we have a joint will? So can a couple decide, let's do this together, so that regardless of who passes first, the will covers both of us? Can you have a joint will, a living will? I've heard the term. What does that mean? What is that? And Nana, maybe you can.
A living will. I'm not too sure what is meant by a living will. Is it to say that you are gifting your assets or properties whilst you are alive?
Normally, the living will takes effect when you are still alive. And a lot of times it covers what you want to be done in a medical situation. So, for instance, we will have a do not resuscitate clause in it, or if I collapse or something, I shouldn't be revived, etc. So, unlike a regular will that takes effect after you have passed away, a living will takes effect when you are living, and most of the time is to do with the end, what leads to the end.
Okay.
In terms of medical care.
Is that common in our context in Ghana? Is that connect?
It is not.
It is not. I've never come across it here.
Okay.
No.
Yeah.
Interesting. So, what are the key components of a will? What should go into a will? Are there, maybe think of it in the context of subheadings or sections in terms of what should be on a will? What are some of the key components? And maybe you can start. Okay.
Okay. I think that for one, you need to describe who you are. So there should be no ambiguity as to the person making the will. And then that requirement of non-ambiguity should run through from the beginning to the end, so that wherever you make mention of somebody or an item, an asset, property, whatever it is, bank account, whatever it is, you should not leave any room for anybody to cast doubts as to the ownership or even identifying that particular asset that you want to give away in that will. Ideally, usually what you do is that you deal with the landed properties first, where you talk about your houses and all of that. And then you come to touch on the movable properties like cars, chattels, your household items, jewelry, kente, and all of that. And then you can also talk about if there's a business that you have shares in, or you have interest in, or you have some investment somewhere and all of that, you can also talk about that in the will. So this is how generally you structure it, but there should be no ambiguity as to who you are describing or the property or asset you are describing. Again, it is important to name who your executors are. And that one too, there shouldn't be any ambiguity as to the persons you've chosen to be executors. Some people decide to say, okay, I'm going to make the head pastor of this particular church as my executor in the will. But you see, what happens is that, yes, you may be a member of that church at the point when you are making the will. And at the point you are making the will, you knew that this is Osofo whoever, who is the head pastor of that church. But when you are no more, it may be a different person altogether. How sure are you that that person is going to be able to take care of your affairs that you have stated in your will? So I've had experience where there's been issues between persons who have been named, just the title instead of a particular individual, the title of people who have been named in a will as executors as against the family itself. So it's usually advisable to name somebody that you know you can trust, that you know would be responsible enough to take care of your affairs in the will.
Okay. Anything you want to add, Eileen?
Yes, I just wanted to add that it is very important the people you name as executors in your will. Normally, people will choose, like Nana said, a pastor or somebody they know who might not want to take on that responsibility of distributing the assets. So it is important who you choose, because a lot of work goes into being an executor when it comes to the distribution. So the person should be responsible enough and willing. There are people who have actually said when the will was read that I don't want to do this job. I don't want that responsibility. Yes. So when you are choosing somebody, it's advisable to choose somebody who is prepared to carry out that job.
Okay. And you're talking and referring to properties and distribution. What if I have no property? What if I don't have landed property? I don't have anything. I only have my SSNIT. I worked in the formal sector and I have my SSNIT, and I'll move on to SSNIT in a second. But if that's all I have, or maybe I'm in the informal sector and I feel I don't have anything big that I can share, is a will still necessary? Is it still useful?
Very necessary, very useful. You may not have landed properties, but you may have movable properties like a car. You may not have landed properties, but you may have, in fact, you have clothes, you have jewelry, you have this, you have that, you have that. And these are all subject to a will. You can will them as to who should take over your clothing, your kente, and all of that. So it's very important. Again, also because of the fact that, like I mentioned earlier, it gives you the opportunity to tell whoever is going to be your executor that this is how I want my funeral to be. So it's not just about distribution of property.
Okay.
How do you want your funeral to go? Where do you want it done? Do you want a big funeral or you want this? And there are some people who may have some kind of investment elsewhere that they've just put aside for the conduct or for the preparation of their funeral because they don't want to put their families through unnecessary financial burden in terms of organizing their funerals. So it is at that point, it is only in a will that you'll be able to tell that, Osimesi had this investment with this financial institution, which he has clearly stated that that is what should be used to organize his funeral.
Okay. All right. And I think one of the things you said ties in nicely with switch to SSNIT for a second. If I have investment or if I have my SSNIT, I've been contributing to SSNIT and I have a beneficiary in there. Does somebody else does the executor, for example, need to know? Well, you mentioned ask people so that you don't put somebody in there who will later on shy away from the responsibility. But is there a role for the executor when you are making the will, besides informing them? Is there any role that they play? Either of you can take it.
Normally the executors don't even know that they are executors in a will.
Mm-hmm.
They have no role to play.
Okay.
You just put them in there as the people who should manage all the affairs afterwards. I mean, if they are people that you want to inform, you can. There's nothing that says you shouldn't. But normally they don't know that they're executors.
Okay, thank you. I'll come to the issue of passwords and information. So beyond property, just information and access. I'll come to that in a second. Charles, thank you very much for being present. What has SSNIT and benefits got to do with this? When somebody passes, I mean, is there a need, and the person had been making SSNIT contributions, is there a need for anything to be done? Who needs to step forward? Who can come to SSNIT? Can I just show up and say, hi, my, uncle or auntie is no more, and I know I'm the beneficiary on her account and I want to claim, but what happens? Just walk us through how SSNIT comes in.
All right, so with the SSNIT survivors, we call it survivors benefit. So when a SSNIT contributor dies or a pensioner below the age of 75 dies, then there is some benefit to be paid to the validly nominated dependent. So if a pensioner dies after 75 or after 72, that is 72 for those who retired under the PNTC law 247, which is virtually phasing out. So for those pensioners after 72, there's nothing to be paid to their dependents who have been nominated. Then for those of us under the Act 766, that is the National Pensions Act, which is in operation now, if a pensioner should die after 75, there's nothing to be paid to the validly nominated dependents. So once a contributor or pensioner is dead, any of the family members can walk into a SSNIT office to report the death of the member or pensioner. Once that is done, you virtually activate the processing. So for this pensioner, we always advise that as soon as the pensioner is dead, the report must be made. So we'll stop payment into his account. If we don't stop payment, once you come to the processing, we have to go through another channel. But for the regular contributor, once the report is made, we start investigations to confirm if indeed the person is dead. So if people come to the office and say, this person is dead, we'll require evidence of death. And the primary evidence we always request is death certificate. We've had instances where people cannot produce death certificates. So in the villages where people die and they are buried virtually instantly, the chiefs are there, the religious leaders are there to do some form of certification. And the SSNIT officers will also have to go and do investigations to be sure that people are indeed dead. Because we've had quite a number of cases where people are not dead, but families report that the person is dead to come and try and claim the benefits. So that is the first process. Once we identify that indeed the person is no more, we will go and check the people he nominated. So look at the list, and those that have been nominated, we apply and distribute the money. But there are instances where people have been mentioned. At the point of nomination, it was a valid nomination, but before the man or woman died, it was no longer valid. So we'll have to look at that and determine. So that portion of the benefit, which is or the percentage that was given to a person that was not validly nominated, will have to apply the interstate succession law to redistribute that portion of the benefit.
Okay, let me interrupt you for a second. We'll talk about someone passing on interstate, but what is a valid nomination? I mean, what does that refer to? Or what makes a nomination valid? Just the verification or?
All right, so with the nomination, the law clearly states people who qualify to be nominated, and those must be family members who are dependent on the contributor or pensioner.
Okay.
So the person might have nominated his wife, but at the point where he passed on, the wife was no longer the wife. The wife or husband had become an ex or a former wife. So that person has lost that connection to the person. So that would be an invalid nomination. We've also had nomination of, let's say, an uncle or a niece who has predeceased the dead. So that is also an invalid nomination.
Okay. So this means that when it comes to SSNIT beneficiaries, it's something that people have to update regularly. Is that something you recommend?
Yes. In fact, the law says that we should update our beneficiaries at least once every 5 years. And I even say on various platforms that you can update your SSNIT beneficiary as often as possible at no fee. So if you get home and your spouse makes you happy, you can come and add the name. The following day, if he or she makes you unhappy, come and take the name off or reduce the percentage you allotted.
Wow. Okay. I have a comment on that, but I'll leave that alone for now. We hope people don't do arbitrary things and just show up to make changes at will.
Yeah.
All right. One of the things I wanted to touch on, and this comes to SSNIT also, technology, passwords. Are these relevant in a modern day will? In terms of knowing what somebody's putting down your social security number, or saying, here's information that you may find online, which gives you access to, or which serves as a key to information that is critical. Is that necessary in a will? Passwords, etc., PIN numbers? And let me do Nana, Eileen, and then Charles.
I think that, in fact, it's a very brilliant question, given the age that we find ourselves in terms of these days, people have Bitcoin accounts and all of that, digital money, digital currency. And these are, I've read stories on the internet where people have misplaced their passwords to their digital currency accounts, and they are in a whole mess altogether. And so I believe that, yes, it is something that you can share in a will, so long as it gives you or whoever you are willing it to access to whatever it is. But because of the nature of how wills are read and passwords are supposed to be private, perhaps what you can then do is to put in place a mechanism where you don't necessarily state the password ditto in the will itself, but you keep it somewhere that the person can have access to it.
Okay.
So that it is not, when you are reading, it is not everybody who gets to see or hear the entire password being read out. Because usually what happens is that the will is read in the presence of the family members. So although you intend Kojo Menu to have access to your password, because Abna Dapa is there, Abna Dapa will hear it and may act on it before Kojo Menu does.
Okay. Okay. Eileen?
Yes, I was going to add on that, the essence of the whole will is to make sure that when you are not there, things can get done. So if these passwords and what was the other thing? You said passwords. Okay.
PIN numbers.
If these passwords, PIN numbers are going to unlock things for, let's say, a beneficiary, then by all means you should let the people have it. For instance, if you draw up a will, we put the bank accounts in the will to make it easier for the person to go to the bank and say that, this bank, this account. So it should be made available. But like Nana was saying, if you put it in the will, then everybody is going to hear it. So you can make reference to it and maybe direct where something like that can be found by the person who you want to have that information.
Okay. And Charles, very quickly, if I show up and I say, here's my dad's social security number, is that enough, or the death certificate is a must?
Okay, so the death certificate is a must, or
Okay.
any other evidence of death. We need that. So
Will you
if it come
accept
without
an
the
obituary?
obituary, we've had a lot of issues where a man prepared his own obituary and came to lodge his death. I mean, the wife came to lodge the benefit. We started processing. We did quite some investigation, and we got to know that the man was alive.
Okay.
So eventually we had to cause the arrest and all that. But this is the point. You may not have your father's social security number or your mother's social security number. You remember the name, the date of birth. That is enough for us to be able to retrieve all his records. And we used to have a situation where people could view their nominees on our online platform. And that also has been disabled for now. So to help people have some form of security, because you leave your password, people go and check and they realize that left me out of the social security beneficiaries, or Akusia is having 50% and I'm getting only 10%. All that could cause a lot of issues. So for now, it is not available online. But once you walk in and you can prove the death of the person, that is enough for us to start a processing. And the point is, if you walk in, you may not necessarily be part of the beneficiary. So people feel the head of family does not want to give me the document. He wants to go and do it himself. Please let him do it himself. He will start the process and make your work easy for you.
Okay. All right. We will talk about people passing on interstate in a second, but let's exhaust this a little bit more. Beyond my personal property, what about my business? I'm a sole proprietor. I own my AC Ventures. Can I will the entire business to somebody? And then, so perhaps, Nana, you can start off with that, and then Eileen can handle what if it's not a sole proprietorship and it's a limited liability company. I own the company with other people. What do I do in terms of the law?
For us here in Ghana, there are various vehicles for doing business. One of them is what you mentioned, sole proprietorship. A sole proprietorship is not a separate legal entity. So the law recognizes it as you, AC Ansa, you are the one. So you are one and the same person, except that you are trading as a certain business name. So it could be Oja Ventures. So Oja Ventures is the business name, but you are really the person who is a sole proprietor or in charge or owns that business. Under those circumstances, you can simply will it without any issue. You can simply will it without any issue. But remember that once you will it, it means that, of course, it means that the liabilities also come with it. So whoever is taking over would also bear the liabilities that come with the business.
Okay.
Well. Yes.
Wow. All right. Thank you, Eileen.
Yes. So a limited liability company normally comes with shares. If you are the 100% share owner, then it means the company is 100% yours. And you can will all your 100% shares to one person if you so wish. If you are a part share owner, so let's say you own 50%, and then there are two other people who own 25%, you can only will what you have. You can't will more than what you have. So you can only will.
Oh dear, I think we lost her.
Two other people. So you can't say that it's my business, etc. I know that for a lot of us lay people, once that we formed the company, even if we give our children shares, we forget that it means that they are co-owners with us. And I have seen instances where people have willed companies and shares to other people, forgetting that there are other people who are shareholders, and so they couldn't have done that. And it's brought about a lot of problems. So you can only will the shares that you have to somebody else.
Okay.
And if I may just add to that,
Sure.
I've had instances where people attempt to, say, appoint others as managing directors or head of finance, or into managerial positions in companies that they are shareholders of. And it turns out to be very problematic. You cannot do that. There are processes to be followed in each company for the appointment of these persons in managerial positions. So the fact that you are a majority shareholder, or that you are a shareholder in a company, and that you were the managing director at the same time, does not mean that when you are making a will, you can decide that Ajwa Mansa, who is your first daughter, should become the managing director when you are no more. You can't do that.
Okay. All right. And Charles, question: can I name an institution or organization as a SSNIT beneficiary, or does it have to be an actual human being?
No, you can't be an institution. It has to be a human being. It has to be a family member.
Okay. All right. Thank you. Okay. So what happens if a family decides, we've seen the will, but we're not going to go with the will. The person is gone. They can't do anything. Let's go ahead with what the family wants. What happens? Can somebody in the family take other people on and make it a legal issue, etc.? What happens? Besides the fear that a ghost will come and catch you.
By all means, once the will has been found, then by all means somebody can take the family members on and try and enforce the will once it's been found. I have been in a situation where somebody showed up and said, I found the will, and all the family members thought that it had been forged. And when I looked at the will, I knew that there was no way it could go to court and probate would be granted. What it means is that there was no way that will could go to court and a judge will accept that this is a valid will. There were so many cancellations, so it says, let's say I give my car to AC, then it's cancelled, then on top of AC is written AMA. And I mean, the Wills Act does not make room for these kind of situations. So I told them that there is no way this will pass probate in court. It doesn't, the requirements of a valid will are not found in this will. So in the end, everything went under the interstate succession law. But this is where they all agreed. But if there's a valid will, there's a will found that appears valid on the face of it, if some family members decide that we won't go by it, there will be those family members who can go to court and ask that that particular will is admitted into probate and acted upon.
Question: must a will always be written? Can it be an audiovisual message? So I leave a video walking through. Is that admissible in court?
Unfortunately, for our laws, it says that a will must be written. It must be written, it must be signed and attested to by 2 witnesses. And you'd be surprised to learn that the law requires that you sign, those who are witnessing your signature, you need to sign in their presence. So they should see you signing the will. Otherwise, it is invalid.
Okay. Wow.
Yes.
All right.
And just to add on, in our laws, unwritten wills are only made for armed forces people. Yes, and it should be if it's unwritten, it should be before 2 witnesses. So only somebody in active service can do an unwritten will, and it should be before 2 witnesses.
Okay. All right. Thank you very much. And the big question, and I think where there's clarity, where there's a will, for the most part, The toughest and most difficult part is where there is no will, where somebody passes on interstate. So let me hear your general thoughts on that, and specifically, somebody passes on without a will. What happens? Nana, Eileen, and then let me go to Charles as well. So Nana, go ahead.
Oja, the subject of interstate succession is a whole session on its own. I'm not sure if we can digest it fully, but in simple terms, in very short summary, what it is that PNDC Law 111 is the law that regulates interstate succession. And by that law, it gives you one, who are those who qualify to apply for letters of administration from the courts. That is one. Number two is that it gives you a formula for distribution of property. It gives you a formula for distribution of property. Now, you may even have to rely on the interstate succession law even where there is a will. So there are instances where you would have to apply both what is in the law, what is in the will, and what is under the PNDC Law 111. There are several of them, which is why I say that we would need a whole session on that to be able to discuss fully interstate succession law. So perhaps we can arrange another session to look at that in full.
Okay, great. Eileen, anything that you think is still important for us to know?
I mean, I always say that make a will so that your loved ones can get what you want them to have. Because if you don't, then the law steps in and distributes your assets the way it deems fit. And so if there's somebody that you want to have something, or there are some people that by all means you don't want them to have anything of yours, then you have to make a will. Otherwise the law steps in. And like he said, PNDC Law 111 is an exhaustive topic on itself. But basically what it does is that it gives you proportions of what people like your spouse, your children, surviving parents, customary family, what they can have. And it's given proportions like percentages or fractions as to this percentage goes to wife and children. And let me add that in Ghana, we don't have any illegitimate children. For as long as your father accepted you when you were born, as they say, and children, it means right.
Okay.
And sometimes this causes a lot of problems because we live in a society where, whether we like it or not, a lot of people have multiple families. And when it comes to all the children sharing that property with their spouse, it becomes problematic. My experience has shown that where there's a man, and I'm saying a man because it is typically men, where there's a man who has multiple children from different women, when men find themselves in those situations, they don't make a will. Because I personally think that it's difficult for them to sit down and share who takes what and who has what. So a lot of times, from my experience, they just leave that. And they are thinking, okay, the law should deal with this when this situation comes up. I don't want to be the one writing that Amma and her children have this and AC and her children have that. So that's interstate succession law for you.
Okay. I know wills and SSNIT, have SSNIT is totally different, but any thoughts on this before we move off, Charles?
All right, so for the SSNIT benefit, it's not part of the person's estate. So that has a separate guiding, let me say, nominations or will. So the Social Security Act provides for it to be dealt in a certain way. So where the man or woman dies and we have, say, invalid, it becomes interstate. So that one will still have to go and apply the PNDC law 111. So the man nominated only one person who has predeceased him. So you have the benefit without a nomination or a valid nomination. So that one you have to apply PNDC law 111. But even where you have valid nominations and you have a minor who has been nominated, but that minor has, say, 10% of the total benefit, the law requires that we vary it and give the minor 60% of the total benefit. And even if the minor was not nominated, that minor will be brought on and given 60% of the total benefit that should go to the family.
Okay. All right, great. So thank you very much. So far, it's been very, very informative. And we received some questions before the session, and we have a ton of questions in the chat box. And so I'm going to run through these literally, zooming through so that we can answer them very, very quickly. All right. There's one about the cost of preparing a will. Some people feel that it's costly. We've had a question in the chat box and also before the session. Generally, how much does it cost to prepare a will, and do I need to engage a lawyer all through, or can I just write it on my own and get the witnesses and go and hand it to a lawyer? That admin part of the process, could you please share a little on that? Either of you. Eileen?
Okay, yes. It's advisable to have a lawyer do it. The reason is that the Wills Act has certain specifications that if you are not a lawyer, you might not know how to handle it. For instance, you need to sign at the end of the will, at the very end of the will, okay? You need to have two witnesses. They should be present when you sign it. Both of them should be present, and you have to sign in their presence. They have to sign in the presence of each other. And this is normally stated at the end of the will, that Kwesi and Amma, both of us being present and witnessing the testator signing it, and that we also signed in the presence of each other. So a statement like this should come at the end of the will. If you are not a lawyer, you might not know it. You might just write things down. You have two witnesses, and then you sign it in your office. You take it to Kwesi's house. Kwesi signs. You take it to Amma's house. Amma also signs, and you think you have a valid will. But then at the end of the day, these things come up, and then your will is declared not valid. Then cancellations, for instance, you cancel somebody's name, you write somebody else's name on top. You think it's nothing. Then you are not there. The will is taken to the court for probate, and somebody challenges it. Then it becomes an issue. Personally, I don't use a beneficiary as a witness. Nobody says you can't use a beneficiary. But once the person is a beneficiary, I prefer not to use a beneficiary as a witness, because what if somebody challenges it, that there was undue influence, that the beneficiary influenced you because she saw something in your will, or she saw that her name was not in, and so, so once there are issues that somebody can raise against your will, a lawyer will try and take out all these issues out, so that at the end of the day, your will can pass probate. So that's some of the reasons why it's very important to engage a lawyer to do it.
Okay. We have a question that says, in case the lawyer dies before the person who, made the will, what happens?
Okay, so usually as standard practice, there are always 3 copies of the will. One is kept with the lawyer, one is kept with the testator himself or herself, and the last copy is kept with the High Court within the area where the testator lives. So usually you deposit it there, they seal it, they have a record of it over there. And so whenever the testator passes, what happens is that you need to write or find out, you can conduct a simple search at the registry of the High Court where the testator had his or her last abode, place of abode, to find out if there is any will which has been lodged or deposited in that registry of that court. bearing that person's name. And they would fish it out if indeed such a document exists with them. But even where the lawyer dies, lawyers operate in firms. And unless it's a one-man law firm, you have a safe. Every law firm has a safe where they keep these sensitive documents such as wills, because the will is not supposed to be in a file somewhere. No, it's supposed to be kept in a safe, locked. And the law firm has its own mechanism of passing on the passwords to that safe. So definitely, if indeed it does exist, it would be made known. In fact, the law requires that if you are a lawyer or if you are aware that Osimesi made a will, you are obliged to report the existence of that will. The law requires that you report the existence of that will so that it can be dealt with in the manner as prescribed by law.
Okay, great, thank you. And then joint wills. Can a husband and wife make a joint will so that they have just one documented will? Lady Eileen?
Yes. I haven't come across a joint will in our jurisdiction where two people make one will distributing their assets. I don't know if Nana has come across that. But normally what I do is a mutual will where everybody has their own separate wills. But for instance, let's say the husband and wife own a house equally. So if the husband says, I give my interest to my daughter Isi, the wife also says, I give my interest to my daughter Isi, so that at the end of it all, the daughter Isi has the house. So it's mutual, but it's not joint. Everybody has their own separate wills, but their interests go to the same person. Or for instance, another example is a wife makes a will and says that I give my interest to my husband for his life. And then at the end of his life to my daughter Isi. And then in the husband's will, he also says, I give my interest to my wife for her life. And at the end of her life, to my daughter Isi, which means that all things being equal, when both of them pass away, Isi becomes the owner of the house. So it's mutual, but it's not joint.
Okay.
Yes, so I've also not come across a joint will before, but to speak directly to the question, I've also not come across anywhere in our legislation which prohibits or makes illegal a joint will. So it's still something to be seen, to be experienced, whether the courts would accommodate or, as it were, accept such a will. But there's nothing in our laws which prescribes that. And then the question as to how much it costs to create, for a lawyer to do a will. There's a scale of fees for all of us, for all lawyers. And it's a guide as to what a lawyer should charge in terms of the services that are being offered. From experience, what I've learned is that for a simple will, where you say this goes to Amma, this goes to that, you can be charged as a minimum amount of 5,000 Ghana cedis. And for more complex wills here would mean wills where you set up trusts within the will. So the lawyer is supposed to set up a trust within the will and all of that. Under those circumstances, it would come at a higher rate than the minimum charge of 5,000 Ghana cedis. But of course, it's always subject to negotiation.
So is this one of the situations where somebody may say, my nephew is a lawyer. Why go find an external lawyer? Let me ask my nephew to be the lawyer taking over, helping me with this. Is that advisable? Or because that lawyer is a family member, is not advisable?
If you trust your nephew to keep it strictly confidential and won't divulge the information to any family member, your brother or your sister, by virtue of which the person became your nephew, then fine, so be it. But other than that, so long as the person qualifies to help in drafting a proper will for you without creating any problems in there, I think you should be able to take advantage of that.
Okay, Eileen, you wanted to say something?
No, I was going to say that confidentiality is key. So if you can trust that person to keep quiet about what he or she has seen in your will, then that's fine.
We've had a couple of questions about who can be a witness. Are there any requirements in terms of who's an ideal witness? Do they need to be certified in any way? You know, who can be a witness?
There's no requirement as to who a witness can be. Okay. But just like anything else, the person should be an adult and of sound mind. And then I always say that somebody young enough, when I say young enough, in the normal course of things, we always think that the older person is going to pass away before the younger one. So I say somebody young enough, just in case somebody challenges the will, then that person is around to say that, no, I was there when the testator signed, he was of sound mind, he was not influenced, etc. But there's no formal requirement for who can be a witness.
Okay, all right, great, thank you. Okay, we have a very detailed question here. One says, what is the difference between a deed of gift and a will? And can a deed of gift take the place of a will? So,
okay. A deed of gift, like the name suggests, is a gift that you give to somebody whilst you are alive. So when you make a deed of gift, right now, let's say you have a house, you make a deed of gift. The person assumes ownership of that deed of gift once you've made it. You don't have to pass away before, unlike a will, which takes effect after. So there are people who gift all their belongings whilst they are alive. And depending on who you have gifted it to, they may allow you to use it. So for instance, if you gift your house to your child being your child may allow you to continue using that house till you pass away. But once you've gifted it, it's no longer yours. Unlike a will only takes effect after you have passed away.
Okay.
Just to add to the deed of gift, what is important to note also is that deed of gift, like she said, is you can put it down in writing that you are gifting this to Osimesi and all of that. In other circumstances, traditionally, you can also do the gift by calling whoever you want to gift the item or the property to, and then you call other persons as witnesses. And then you tell them in their presence that I, Osimesi, am giving this house located at this place to this person, so that they all know whilst you are alive that you've given it to this person. Ordinarily, under customary law, you are supposed to do something known as asida. Asida is where you bring, let's say, some schnapp or some hard liquor, or you bring some chicken or goat or sheep or whatever it is to come and say thank you to whoever is giving you that gift. And that is recognized by our law as a gift. It's recognized by our law as a gift.
Okay. Yeah. All right. We have another question that I think, this has been addressed. How often should one revise the will? What's the process like? How often should one revise his or her will? What's the process like?
You can revise your will as many times as you want. So sometimes some people, let's say every 5 years, would revise their will. What we would normally do is to write to the court, retrieve what is there, and then deposit another one.
Okay.
And normally, if you are writing another will, you would say in it that this one cancels everything else. So even if you don't retrieve what is there, once you make another will, which states that this one takes precedence over any other will, it automatically invalidates the previous ones. But there's no requirement as to how many how many times you can do that. Normally, when people acquire new property, they make a new will and distribute that new property. When people fight with their children, they make a new will and take them out. And then when they reconcile, they do a new will and put them back in. It happens all the time. So there's no requirement as to how many times you can do that. I have seen wills that have been retrieved after 28 years, which I think is too long. Yes. I just did one. The will was deposited in 1993. And if you look at what is in the will, you would realize that a lot of the properties have been disposed of, and the person has in the last 28 years acquired new properties, but there was no update. So what it means is that we have to go by what is in the 28-year-old will. And then some of the properties that have been acquired later on fall into what we call residue. Let me explain quickly what residue means. When you make a will, sometimes you might forget to mention something. And so we put in a clause that says that anything that I have failed to mention should be given to AC. And so once we have that clause, then at the time of reading the will, all the properties that you have acquired, all the properties that you have acquired that are not mentioned fall into the residue, and that goes to AC who has been mentioned in the will.
Okay. All right, great. Question here says, where I lost it. Okay, can you add things yet to be acquired to your will? If you say, I have this land and I hope to build on it within the next X years. So that house that is yet to be built, can you put in things that are yet to be acquired?
That's interesting. As far as I know, you can only gift what you own or have in a will. So if you hope to do something, yes, it's a declaration of intention. That's fine, but you don't have it. So what it means is that if by the time you are no more, there's a house on it, all right, but it was built by someone else, that can be because it does not belong to you. But if it was built by you, then fine, it passes. But other than that, you only give what you own. You can't give what you do not have.
Great, thank you.
AC, to add on quickly.
Sure.
There are certain rights that are clear-cut that you can put in a will. For instance, if you've written a book and you know that there are some royalties that are going to come out of that book, for instance, you would be able to will that. I hope you get the difference between that and the house that Nana was talking about, because you see, whereas in the house, somebody else could now go and build on that land. And then now you, in your will, you'll be giving out a house that is not yours. When it comes to something like royalties in a book, those are yours and you can will that to somebody.
Okay.
Let me be quick to add something here about houses and all of that. Please note that when you build a house on family land, it is not for you. It is for you.
Okay.
When you build on family land, the law in this country is that it does not belong to you. It belongs to the entire family. So you cannot will that property to somebody in a will. You can't give it to somebody in your will, simply because you brought the resources, you supervise the building and all of that. So long as it is on family land, it's not for you. It's for the entire family when you are no more.
Wow. Okay. I'm sure there might be a follow-up question with regard to that specific one. There's a question here that says, does the will supersede beneficiaries nominated on your SSNIT? and investments in the instance where the names on the will are different from beneficiaries nominated. So there's somebody nominated as a beneficiary on the SSNIT and totally different set of people in the will. Does the will supersede, or maybe in my will I say so and so should be a beneficiary. Maybe I forgot to go and make the change at SSNIT. So Charles, over to you.
The will is independent of the nominations. So we've had some of these cases come up before. We've had to go to court. Unfortunately, some of these cases ended at the High Court. So, I mean, the decision of that will not be binding on another High Court, but it's often not been able to go through. The law governing Social Security operations have clear forms by which you will have to nominate your beneficiaries. And as I stated earlier, the Social Security benefit is not part of the estate, and there's a decided case on that. So at that point, your will not superimpose that of the nominations you did at SSNIT. So right from the time you joined the scheme, even before your contributions started coming in, you did your nomination, indicating that you are so much aware of what has to be done. And we try to update people and let them know that you can only update your nominees as SSNIT and not through your will.
Okay, all right, great. And one question that I think people may not have caught the answer to, if the lawyer passes, we are presuming that the will is already lodged at the High Court. What if you have a lawyer who passes before that is done? What happens? Who then, takes that up? Or if it's a one-man lawyer and we're not too sure, what happens with documents, etc. once the person passes?
Okay. If your lawyer passes, like Nana said, you can do a search at the High Court. Okay. Anybody can do that search. You just write to the registrar. You say, did this person by this name deposit a will here? It helps if you can at least give the year. And then they will do a search and say that, yes, the will is here. If the lawyer has passed away. If the lawyer did not deposit the will, and the will is in the lawyer's office, and nobody ever finds it, and nobody knows that the person made a will, then it is presumed that he did not, because nobody has come across it. If the person has a spouse who knows that the person did a will and can trace it either from the lawyer's office or from the High Court, then the court can act on it. But if nothing comes up, it won't be enough just to say that he told me he made a will. If you say he told me he made a will, it has to be found. And if it's not found, then the presumption is that he did not make it. And then PNDC law 111 will apply.
Okay, thank you. There are a couple of questions I'm going to take the liberty to answer. Is there, at what age must one write a will? And I'm presuming, okay, I was going to answer, but let me have the lawyers take a swipe at it, because I think a lot of young people think it's for older people. So the default response is, don't think it's about property, but 18 and above, so long as you're not a minor, I'm presuming that you can write your will. So please confirm and let me start calling myself lawyer answer.
I think,
right.
You can call yourself lawyer answer.
You can.
Okay. One says, can more than one executor be appointed? Can there be more than one executor to a will?
Oh, yes.
Yes. The law does not prescribe the number. More than one person can be an executor. All you have to bear in mind is that they have to work together. And if you have 15 executors, it's going to be very difficult for them to come together and do everything. Sometimes people have appointed just one, but from my practice, I have realized that normally 2 to 4 is the common number of people appointed as executors, but the law does not prescribe any number.
Okay. Question here, can a commissioner of oaths serve as a lawyer or do the same job as a lawyer as what we have here?
I think that, like my senior mentioned earlier, see, there are certain technicalities about a will that is known to lawyers. And for instance, if you want to create a trust in a will, a commissioner of oaths would not necessarily, unless the person has some legal training, the person would not necessarily understand how a trust is created, what are the legal requirements for the creation of a trust and all of that. So under those circumstances, you may have some limitations there. But if it's a simple will, even you can create your own simple will. But then it's always advisable to engage a lawyer to do that. Because there are, for instance, my senior mentioned residue, so residual property. Most people create wills without making provision for what should happen to properties that fall into residue. Under those circumstances, what it means is that those properties will fall into intestacy. So that's one of the situations or scenarios where you would have both a will and the PNDC law 111 applying to such a person's assets.
Okay. Okay, great.
It's always advisable to get a lawyer.
Okay. You shouldn't shy away from, getting a lawyer.
I think the fees are quite reasonable. That's one. And two is that you can always negotiate with a lawyer. And in most cases, you can even decide to pay in installment over a period of time and all. It's always a matter of negotiation between yourself and the lawyer. And I think that it's something that can always be worked out.
Okay, great.
It's better to do that than to create problems when you are no more.
Okay. Question says, what if the clan or family gifts you part of their land? You go through the formal expression of gratitude. Can you gift a building on it to your child?
It's still family land.
Wow, okay.
I didn't get the question right. He said, what if a family
gives you part of the land? So here's the family property. We've cut off one plot for you. You accept it, and then you put up a building on it and give that to your child.
So that one plot now becomes your personal land, because you see, the owner of the land is the owner of whatever is on top. So that one plot, is it given to you as your own personal property? Is that what the question is saying?
Okay, so I'm going to ask
such that now it's for you alone and not part of it.
Okay, so I'm going to ask the person who asked this if she wants to clarify. And I'm presuming that if that gift is not documented, it's just a verbal gift, then it's still family land versus now you have that one plot in your name.
Precisely. Right? So the safety here, the safety here will be to one, have the family or the clan execute a deed in your favor, transferring the land to you. So there is documented evidence of the transfer of interest to you alone. And then you make sure that you take steps to register it as well. So that in future, nobody comes challenging you. That's family property. Because most of the times, the mistakes that people do or make is that, okay, ebusiani dia mame, and you know, makwa kwaye a 2-bedroom self-contained be also. Mene membati ho. Inti me ye wela na me de will me de sa 2-bedroom self-contained no ama membano. When there's no document showing that indeed there was a transfer.
Okay.
It is family property.
Okay. All right. What happens if the executors pass on before the reading of the will? So
That's my senior.
That is always a problem.
okay.
Sometimes if there are 3 executors, the 2 or 1 who is surviving would go ahead and do the work.
Mm-hmm.
There have been instances where all the executors have passed on.
Mm.
And then in that instance, we look to their executors to continue, yes, to do the work that they did not do.
Mm-hmm.
For instance, where there's landed property, the executors have to vest that property in the beneficiary. It is when I say vest, it's a legal document that gives you that ownership. When the executors are not there, their executors will have to vest that property in you. It happens where we have written to an executor's executors saying that so and so was an executor under this will, and they were not able to complete their duties as executors. And so we are writing to you to complete it. So that's what happens.
Okay.
Let me add to that. In instances where it is impossible to have an arrangement like that, and the executors pass maybe at the same time when the testator also passes, and there are no executors to fall on and all of that. It's also one of the instances where the will would be, you can have letters of administration with will annexed.
Okay.
You understand? So you have LA, the court will appoint administrators, but this time round, the distribution will not be in accordance with PNDC law 111, but it would be in accordance with the contents of the will. You understand? So you would have administrators, but with will annexed to it.
I have a question that touches on investments and SSNIT. And so, Charles, let me get you back in. And then our next question after this for the 2 lawyers starts thinking of a list of things we can look out for to tell whether a will has been forged or not. Okay, so that's the next question. So to Charles, and this also to the lawyers, it says, what about investments? Does beneficiary nomination also have laws that supersede the will? So if I have an investment with one of these financial, institutions, and so what happens where investments are concerned? And then the follow-up question to that is, further to the SSNIT beneficiaries clarified earlier, what about the other investments such as tier 2, tier 3? I'll leave that to you to please handle. So Eileen, you can go. Please unmute yourself, Charles.
With the tier 2 and tier 3 contributions, you are made to do separate nominations. So there are also beneficiaries that you make for tier 2 and that's for tier 3. You may not necessarily want your beneficiaries for the first tier, which is managed by SSNIT, to go to the same group of people. So there's provision for you to nominate someone or people to receive that benefit. And that also is mutually exclusive from your will.
Okay.
So the will not cover that part. Unless something happens, then as usual, we'll go for the PNDC law 111 to redistribute that portion of it.
Okay. So the understanding here would be that every document, whether it's every document that covers your investments will perhaps list, beneficiaries, etc. And that, because it's documented, is what will be carried out, regardless of what might be in the will.
Not every investment. Not every. There are some investments that you make, and they don't come with specific nominations for who the investment should go to in the event they are no more. So that forms part of your estate, which can be distributed through the will.
Okay, great. Thank you. All right, forged wills. What are some of the telltale signs?
Let me start by saying that in my experience, I have realized that anytime people are not happy with what is in their will, they assume it's forged. So, for instance, a father has 3 children, wills out property to 2, and leaves out 1, either because and sometimes the family members have an idea why he left this particular child out. Maybe they were at loggerheads, there's an issue or something. But I have realized that anytime people feel that they have been disinherited, they immediately assume that the will is forged. Sometimes on the face of it, there is nothing that shows that it's forged. The testators have signed, the distributions have been made, there are no cancellations. It looks valid on the face of it. But then the disinherited person thinks that it's been forged. So I just want to put that out there.
Okay.
Sometimes it's not forged. The person just decided to disinherit. There are instances where wills have been challenged. For instance, a current one now, the will was made the day before the person passed away.
Oh, wow.
And there's evidence from the hospital that he was in a coma for some days. So this is a ground for challenging the will because there's evidence to show that he could not have made that will the day before he passed away if the medical records show that he had been in a coma for some days. So in an instance like this, everything looks valid on the face of it, but then you can still challenge it based on that information.
Okay.
Where there are cancellations, for instance, where there are cancellations, for instance, it can make a will invalid, but that could be the fault of the testator himself and might not necessarily mean that it's forged, but the court will not accept this will into probate. So that's another instance. But where the person makes a will and maybe gets the names of his children wrong, for instance, that smacks of forgery. If you think that there is no way this person could make a will and doesn't remember the names of his children, that will be one instance. Or doesn't remember, let's say, date of birth. For instance, if you think that there is no way my aunt or my uncle doesn't know my date of birth or doesn't know my name, but then the burden is now on you to prove to the court that the will is forged. Because if on the face of it, if let's say a parent makes a will to my daughter Isi, and there is no daughter called Isi, but Ajua comes forward and says that I think this will is forged because there's a mistake in my name, the burden now falls on the person saying that the will is forged to prove it to the court, because on the face of it, everything looks okay. So these are some of the things that we look out for, wrong names, wrong date of birth, cancellations. But disinheritance is difficult to prove that one.
Okay. All right. Christy, any 1 or 2 telltale signs? And then I have another question for SSNIT.
Not readily, but I think that one of the ways to avoid this whole rancor when it comes to allegations of fraudulent wills and all of that is to make sure that you deposit a copy of the will with the registry. Of course. There it is sealed, it is stamped and all of that. And it makes it so that if you find the one in the custody of the lawyer or the one in some box somewhere in the testator's room, somewhere, you can always make a comparison to find out if the one which is in the custody of the court is the same as the one that you retrieved from the lawyer or from your grandfather or grandmother's box in the room.
So in the event that the will was updated and you find a copy, let's say a June 2021 copy, but what is lodged at the court is January 2021. Which one? But we can see that the lawyer has signed, etc. It just didn't get to be lodged formally. Which one will the law go with?
The June 2021, so long as everything on it appears that it is genuine. And mind you, like my senior said earlier, usually when you are making another will, you would state in there that you have revoked all previous wills and that this is what is current and this is what should apply. In fact, even when you are making a fresh will, you indicate that this is my last will and testament and that any other document previously made is invalid. This is what I am working with. In order to avoid these kind of situations, that is what lawyers put in there, which is why, once again, it is advisable to always consult a lawyer in drafting these documents.
Okay. Great. All right. Let me mute. I hear some voices. Okay, so I have a number of, so a time check. It's 8 minutes after 5. Our target was to finish at 5, and we have a lot more questions pouring in. And so I'm going to seek permission of everybody on the call to keep going for another 12 minutes. And then what we can do is, once we officially close the room, we can have a few breakout rooms for each of the lawyers. So if you have a specific question, then you can let us know. We'll put you in that breakout room for just about 5 minutes, just so that you can get your questions answered. What I'm going to do is I'm going to read off the questions and assign them so that we can move a little faster. All right. So I have a question here that says, if someone forgets to update their SSNIT beneficiaries, so you chose family members as your SSNIT beneficiaries as a student and unmarried. Later years, you have a wife and children, but forget to change. What happens after your demise? Charles, you can handle that when I'm done reading through the list. Thank you. And then I have one that says, can a portion of a will be accepted and another portion be rejected by the court? So in other words, is there a severability provision for wills? So I'm going to ask Eileen to handle that. And then I have one here that says, what happens to a share of the property when the beneficiary is deceased at the time? Okay, so what happens to a share of the property when the beneficiary is deceased at the time of the reading of the will? So the person passes before they can benefit from that. What happens? So Nana, you can handle that. And then I can come back with a question, maybe a final question that says, look, I need to create a will. Where do I start? What do I do? I have the intention, but where do I start from? So question about beneficiaries that haven't been updated, question about part acceptance of a will, is that possible, etc. And then Nana can handle what if the beneficiary themselves is also deceased. Thank you. So Charles.
All right, so where a contributor or a pensioner fails to update the nominees or beneficiaries, in this situation, the wife or the spouse and children can go to court and apply for variation. That this is the situation, so they go to court, and in that instance, the court will hear the argument from both sides, because the one that was nominated, that person is going to be affected adversely if you are going to take part and give to the spouse, and so they may also put in their case. So the court will have to decide on that instance. Then, but as I said, in the situation where the children are minors, the law grants them a certain portion which will have to be applied. That notwithstanding, you can always go to court and apply for variation, and the court will look at the merit of the case. For instance, the adult child who is applying for variation, was he or she born before the last nomination? That one will be a decision for the court to make.
Oh, sorry, I didn't realize I was muted. Eileen, please go ahead.
Okay, so I think my question was whether parts of a will can be adopted whilst other parts are rejected.
Yes.
The simple answer to that is yes. There are instances where, let's say, you make a gift, you make a device in a will, for instance, and you say that I give my house to my daughter Issy as long as she divorces her husband, for instance. That's a gift that we call a gift against public policy, and the court will not enforce that kind of gift. And so everything else in the will be accepted, and that particular gift can fall into intestacy. That's why you can have a will where other gifts have gone ahead and then other devices fall into intestacy. So yes, they can take some and reject some.
Okay, fantastic. Nana?
Okay, what your question describes is what is known as a lapsed disposition. And the law already makes provision for that where a disposition is made to a person who predeceases the testator, then what it means is that it falls into residue. So the disposition shall lapse and fall into residue. So it falls into residue, and that is where it is important to also indicate what your residual property or who your residual property should go to. So the mechanism in the will is such that it caters for almost every situation. So if you are not skilled in drafting wills, you tend to overlook these things, and it may create problems when you are no more and the will has to be administered eventually. So yes, it falls into residue under those circumstances.
Okay, great, thank you.
Essie, I want to add on quickly to what Nana just said.
Sure.
There's an exception.
Yeah.
Where the beneficiary is a descendant. And the Wills Act defines descendant as your child or your grandchild. So where the beneficiary is your child, for instance, and your child predeceases you, then that gift will not lapse. That gift will go to a descendant of that beneficiary. So for instance, you make a gift to your child predeceases you, but that child also has a child. So that gift then goes to that grandchild.
Okay.
Is it clear?
And if there's no grandchild?
Well, if there's no descendant, then it will lapse, just like Nana said. So there has to be a descendant for that gift to go to the person.
Okay, great. If I have 3 places of official residence, let's say Accra, Kumasi, and my hometown, which of the 3 high courts is advisable? Where is it advisable to lodge the will? At all 3 in those jurisdictions, or in one place is okay?
You can lodge it at all 3.
Okay. Can you lodge it in just one place to cover?
So, because what happens is that, and I've had to advise somebody on this not long ago. His father passed, but before his father passed, his father had lived and worked in the Volta region for so many years. But before he passed, he had relocated to another region. So when he came to me, what I told him was that ordinarily you would lodge it in the high court in the region where you are. But because his father had lived and worked in the Volta region for so many years, it would be advisable to also conduct a search in the Volta region to find out if his father left a will there as well.
Okay.
Okay,
Yeah. That's also. All right. If you have property before you get married and you live there with your spouse, can you will that to only your children, leaving your spouse out? In terms of choice of who you leave what to, my presumption is that it's really up to you, but you want to do what will bring peace once you're gone.
Yes.
Right?
Yes. And I think the question probably, whoever asked the question probably has in mind this this new development thing that matrimonial property belongs to both husband and wife.
Mm.
You understand? Now, the position of the Supreme Court is that matrimonial property, there's a presumption that it belongs to both husband and wife, unless you are able to rebut that presumption with evidence that there was no contribution and that it belongs to only one of the spouses. And so in making wills, I think that these are new developments in the law, which we all need to take account of when we are drafting our will. So if you have property that was acquired during the subsistence of the marriage, the presumption is that that property belongs to you and your wife. And so if you are going to make a will, you can only will your interest in that property.
Okay, great.
You can only give out your interest in that property, nothing else.
Okay. Great.
Essie, I think you also mentioned that you want to do what will bring peace. Yes. There are times that people, for instance, have two houses and then they have two children and they want to will the one house to both of them, one house to both of them. Sometimes when they come to see a lawyer, the lawyer will tell them, if you have two houses that you think you can will one house to one child, one house to one child, that will bring peace, because experience has shown that when you will, of course, if you have only one house and you want to will to 5 children, that's fine. But if you have 5 comparable houses, it's advisable to give everybody their own house, because it is very difficult to get all of them to agree on what to do with the house. I'm in a situation where there are a lot of properties, but all the properties are willed to all the children together. And they cannot agree on what to do with any one of the properties. And all the properties are falling into disrepair. Whereas if maybe 1 or 2 are given one, 1 or 2 are given one, it will be easier for them to come together and decide. So these are some of the things that a lawyer would advise you on if you come with your list of properties and how you want to share it. And of course, that brings peace.
Okay, fantastic. Thank you. All right, time check is 5:19, 20 minutes beyond our start time. I see that it'll be great to hear a few voices, to hear some voices on the session, so that we know we're not just 4 people sitting here chatting. And so I would like to hear, we've exhausted most of in fact, all the questions that have come in. The last question, which I would want you to tackle to help us wrap up, would be, where do I start from? And I know it'll be easy to say, well, see a lawyer. But what are some of the things I need to think of in terms of steps? Before we get to that final wrap-up question, I'd love to hear a few voices. So if you have a question and you can promise to keep it very short, straight to the point, it would be great to hear the responses. And so please feel free to unmute yourself if you have a question for any of our resource people, so they can address your question directly as we begin to wind down. So I see a hand that is up. Mr. Frank, please go ahead.
Good evening, and thank you very much, moderator. My question goes straight on the gift. When you have a client who claims that he received a gift from his father, but there's no document, and he goes ahead to say that, oh, he didn't give me any document, but I gave him drinks to justify that he has given me this, and somebody comes to testify that, yes, I was there when he gave the drink, but there's no document. What do you do, and how do you call that case?
Okay, great, thank you.
Can I come in?
Go ahead. And try and make it very nice and quick so we can take a few more.
Sure. So I mentioned that usually for these customary gifts, you would have the person who is being gifted, who is receiving the gift, and then some other family members. And the asida is performed not between him and the person, the donor, that is the one giving the gift, but again in the presence of family members. So in the event that there's no document, what then happens is that the administrators of the estate of that person would recognize the existence of the fact that indeed there was a gift and go ahead and create a vesting asset that my senior mentioned earlier, so that that person can go ahead and register the vesting asset as proof of the fact that indeed there was a gift that was given to that person.
Okay, thank you. Any other? If there's any other question.
Yes, hi, I have a question.
Go ahead, please.
For example, you've bought a property and you've partially paid for it. You've paid maybe 50% and you hope to be able to fully exhaust the payment in 2 years. Is that something that you can fully cover in your will currently, or you need to wait till you fully own it before you can will it out?
Okay. So, Eileen?
Yes, you see, normally you can't give what you don't have. That's the basic. You can't give what you don't have. So if that property is not yours as at now, then you shouldn't put it in your will. You see, the other side is that if you put this property in your will, and then by the time that becomes necessary, the reading of the will becomes necessary, you have paid for it and everything, then there's no problem. There's a problem when you didn't finish paying for it and then you passed away. Then now, if you have put it in your will, then the beneficiary needs to probably take steps where, for instance, there's an agreement. I know I am bringing other factors into it, but that's how it works. So for instance, you are going to buy a piece of land. There's an agreement between you and the seller where you have a contract of sale, okay? When you have that kind of contract of sale in place, and now your beneficiary can take over the payment and then get that property. Does it make sense?
Yeah, I think that clarifies.
Yes, it does. Okay. It does. Thank you so much.
Okay,
great. I see another hand. Kweku, please go ahead.
Thanks. So my question is, if we have a debt, is there any place in the will to mention the debts that, do we pass debts along, or what do we do around debts in the context of a will?
That's
okay.
Great question.
Very interesting question. And like my senior said in the beginning, executors have a lot of responsibility in a will. What we should all understand is that for both executors and administrators, the law requires that once you assume that role, your first responsibility is to gather all the properties or the assets and then pay off all debts before you come to distributing the properties. So you cannot distribute the properties without paying the debts of the testator. So you must first pay off the debts before you even go to distributing the properties. You would have instances where it becomes necessary to sell a property to be able to pay off the debt. But under those circumstances, you need to talk to the beneficiaries. The executors would need to talk to the beneficiaries to agree so that they understand how these things work. Because ordinarily, once the person passes, you are supposed to let them know as well that this person owed X amount, this person owed this. I'm currently doing a case where I had sued, and then in the course of the action, the person passed away. Now I'm going after whoever inherited him to pay.
Wow. Okay. Wow.
These are things you can never do away with, debt and taxes. You cannot never do away with debt and taxes. They would follow you
into your grave.
All right, great. Wow. That's a great question. I mean, we think of property and all that, the assets, and the liabilities don't often come up.
At all.
You know, yeah. Okay. Is there any other hand? I have one last opportunity, and there's also a little clarification needed on property that is acquired before marriage. Okay, so it's in my name, acquired it before marriage, and want to will it to my children, but not to the person, to the spouse. And if we acquired something while married, that may be left to the spouse or the spouse and children. So the question here is really separating those two. If the property was, in my name before, the question becomes, can I leave that to only my children? Or is the spouse, especially if it's the case where the man leaves it to the children only, and the woman is still alive and is listed as a dependent? What happens in cases like that?
Okay, property, we have property that we call property acquired during the course of the marriage. And when it comes to property rights, etc., it looks at property acquired in the course of the marriage. Property that you acquired before marriage is not part of spousal property. Inheritance is also not part of spousal property, even if you got that inheritance whilst you were married. So for instance, your father passes away and leaves you a house whilst you were married. That does not form part of spousal property. So you can will that to your children without naming your spouse. And there is nothing wrong with that.
Dr. Ify, I think you're muted.
Can you hear me?
Oja, are you there?
Oh, I'm sorry, I had muted. So, Mr. Abraham Kwachi, please go ahead. I see your hand up.
Yeah.
Please unmute yourself.
What are the costs associated with implementing a will? Because it appears that apart from the lawyer's fees, there are other huge associated costs, which it's almost impossible for beneficiaries to bear.
Okay, great question. Thank you.
Okay. When you make a will, the cost is the lawyer's fees, and then the cost of depositing the will at the court. I think what you are talking about is the estate tax that comes afterwards. When probate is granted, then depending on your assets, a fee is paid. That is the estate tax. So that is not normally paid by the person who made the will, because that happens when you are no more. That is paid, or is supposed to be paid out of the estate of the person. And if you have a big estate, then the estate tax is bigger. So that one is commensurate with the size of the estate.
Okay, great. Thank you. The last question was about where we get started. So this is great information. And I'm sure Charles would say, get started by updating your SSNIT beneficiaries if you haven't done that in a while. That would be a good place to get started. And with regard to the will itself, what do we do? I want to create one. Is there a template? And for the information of all our participants, we'll share some, especially if you're interested and you signed up for this, you can also indicate in the chat box. We'll share some resources with you. We'll prepare a list of resources. We wanted to also get a sense of the kind of questions you have, put that together and then share it with you. But for the lawyers, what's the starting point besides going to see a lawyer?
Usually, for me, when you come to see me, what I have a questionnaire that I give out to you. So the best answer to that will be to have an idea or list down all your wishes as to what you want to be done when you are no more. And then you can then come to how you want your properties or your assets that you've acquired in your lifetime, how you want it distributed, who you want to make provision for. Sometimes you may have dependents. Maybe you have some grandchildren that you are taking care of. You may have some other persons that you are taking care of who may not necessarily be your descendants or your bloodline, but these are people that you've grown some sort of affinity for, whom they are relying on you for their livelihood and all of that. You can make provision for that, all of that in your will. So you need to put all of these together. And then once you see the lawyer will then couch it in the requisite language as prescribed by or as required by the law, and make sure that all the technicalities are satisfied before you go ahead and approve of the contents, and then you sign and the witnesses also sign. Yeah.
Wonderful. Wonderful. Thank you. There was a question that said, can I appoint a family head as the executor of the will? That came on YouTube. Is that advisable?
Essie, I didn't hear the question.
Question said, can I appoint the head of the family as the executor of my will?
Yes, you can.
If you can trust them to be objective.
Person is up to doing the task.
Okay. Okay, wonderful. All right, wow, this has been absolutely informative, really, really, really useful. And there are questions still coming in, but unfortunately, we do have to pull the brakes at some point. The last question requires a very quick, perhaps I'll make that a yes or no question. How often can you change your will? We said as many times as you want. Are there cost implications anytime you amend your will? Would you guys like to answer that, please? Cost implications each time you amend it.
I mean, the cost implications would be the lawyer's fee. I mean, I'm sure if it's the same lawyer, it's going to be very minimal. They probably have the template already. They just need to insert sections. So there are cost implications, but it's not going to be as much as the first draft. And then after that, you have to deposit it at the court, and it doesn't cost too much to deposit.
Okay, great. Wonderful. Whew, 5:34. This has been very, very, very useful. Let me turn my video on and let's begin to wrap up with properly. So thank you so much. Thank you, thank you, thank you. We really could go on for another hour or so. The questions are still coming in. And but at some point, all good things must come to a halt. So let me say thank you to Nana Kwesi and to Lady Aline Eskin and to Charles Garshon. Thank you so much. This has been very, very informative. What we're going to do is we have this running on YouTube, and we're going to take the questions and tag the timelines where the answers came. So we'll list the questions, and then at, let's say, the point where the answer came, we'll do that, and then we'll share that so that people can watch and listen. And if you have questions for our lawyers, you can send them to us. And for those of you who would like to reach out to them, may be available to, have a chat with you and figure out what your needs are and if and how they may be able to help you. So let me ask you for your 30-minute final thoughts. Let me start with Charles. Let me go to Nana, and I'll end with Eileen.
All right, thank you very much. It's been a wonderful time. So for those of us who have not updated our beneficiaries in recent times, you can do so now. For those of us 72 and above, there's no point going to update your beneficiaries if you are retired under the PNEC Law 247, because in case you are no more, there is nothing to be paid to your dependent. So just
You make
chill.
it sound so difficult to swallow and quite, that's tough. But anyway, go ahead.
There's a guaranteed period for the benefits payment beyond a certain age. That is why they are required to, as a means to check if they are still alive, we need to be able to complete or renew their pension certificate by visiting them in their homes or by they visiting us in our offices. So either of the two, whatever they prefer, we do. So that is for a year period. So I will say that for the younger ones especially, please and please again, update your beneficiaries today if you haven't done so, and can do so by visiting the nearest SSNIT office across the country.
Okay, and I think we'll have to have a whole session with SSNIT on benefits and this checking in. I can understand the, reason for it, but a lot of the seniors I engage with tell me it's one of the most undignified things they are required to do. So
in fact, those who are able to visit our offices, once they let us know, we come to their homes.
No problem. So I think maybe we'll join hands with you to improve the PR around this. The way it comes across is very negative, right? So I think this is a great opportunity to let our seniors know that there are reasons for that, and perhaps we can join forces with you to help with the education so that it gets across better. So that's a partnership we can discuss. Thank you. Nana? Thank you very much, Charles. Nana, you're muted.
Okay, can you hear me now?
Yes, sir.
Okay, great. Thank you so much, Oja, for the opportunity to be a part of this. I think that it's a very important topic. It's unfortunate that we could not discuss in detail the interstate succession. Hopefully, you'd be able to put together another session on that. But I also hope that the takeaway from this session will be that everyone would take a step to put together a will if they haven't already done that, both young and old. On my part, I think what I would offer to members of age, is that I'm willing to do 5 wills pro bono, simple wills, 5 simple wills pro bono for members of age. So that is my giveaway for this event. Thank you.
Thank you very, very much, Nana. And we definitely will take you up on that offer. Thanks a lot. All right, let's go to Lady Eileen as we wrap up. Thank you.
Okay. Once again, I'm very glad that I've been part of this. What I want to say is that, making a will does not mean you are going to pass away. No. People make wills and 50 years down the line, they are still alive and still updating and still acquiring more things. So making a will doesn't mean you are going to pass away. I mean, passing away is not in our hands, and it doesn't depend on whether or not you make a will. So I will urge all of us to put our houses in order before inevitable happens. And then following in Nana's footstep, I mean, I can't live without throwing in the, should I say challenge, just like he said, 5 wills, 5 simple wills pro bono. Between the two of us, if we can get 10 simple wills pro bono, then I think that will just be a little service that we can offer everybody on this platform. Thank you so much.
Thank you so much. This is more than I bargained for. And it helps me and helps Caleb in his work. Caleb is my business development associate. He's going to mention very quickly some of the things that we don't have time. So he just mentioned them very quickly. And then also, if you have the service that the lawyers are offering, fantastic, but you need to be a registered member. So this is a great way of getting people to formalize their membership of AGE so they can have access to our wonderful lawyers. Thank you so much, Charles, Nana, and Edward. And I'm going to ask Caleb to say a few words about AGE, and then we can officially sign off. Thank you.
Also,
Caleb,
thank you very much, Doc. So I'll make this very quick and snappy, but before then, let me just introduce myself. I'm Caleb Darko, and like Doc said, I'm the Business Development Associate for AGE. For the benefit of those who don't know much about work, basically what AGE does is we address the concerns of seniors. So basically we work with seniors to help. Everything we do is for the benefit of seniors. So these are people who are 60 years and above. And we do this at different levels, from the individual level, community, and the national level. When we say individual, we have programs that we run, like what we are doing right now. I'll quickly go to that and talk about one of the programs. Community levels, we partner with organizations, which are also at a national level. We do advocacy work as well. And just like our lawyers have offered to do this pro bono work, these are the kind of things that we sort of like work and try to come up with for our seniors. Now, to be an AGE member, you have to be 60 years and above. But of course, it's open to people below 60. It doesn't mean that you are not, if you're not 60 years, you can't be a member. There are volunteer opportunities there too as well, which I'll talk about quickly. And then as part of our registration process in becoming an AGE member, we need you to have a valid ID card, national ID card, which will help our team with the registration process. And so if you want to know how you can go about that, you can visit the AGE website. That's ageafrica.com/become a member, or you can WhatsApp us. We put our information down there. WhatsApp really helps us because we can communicate with you one-on-one, and then we can share a link to you where you can fill the form. And if you have any questions, you let us know. And you can also call us on our number, and then we'll have somebody to help you. Now, what are some of the benefits of being an AGE member? If you're an AGE member, you're able to get benefits such as discounts and promotions from our AGE loyalty network. And I believe that what Lady Eileen and Nana Kwesi are doing today is an example of the AGE loyalty network. So you get some of these pro bonos, discounts, and all. These are things we want for seniors. And then also access to healthcare partners. So these are partners who are in the health industry who will be able to help our members in one way or another. Then another thing which is very exciting is our intergenerational activities that we engage in for members, which I also talk about. This helps members with psychosocial support. And then also we provide platform for seniors to just engage with one another, platforms such as our virtual sessions, which we do on a monthly basis. Now, I'll quickly hit on the programs. One of the main programs that we are looking to work on is it's a program we call the Novi program. Now, we realized that during the COVID-19 pandemic period, for example, we realized there was a lot of, because of the people being by themselves, there was a lot of loneliness, limited interactions. And so we came up with a concept of Novi, which is friendship. And so this is an intergenerational program where we would pair seniors and juniors in a buddy system. And so they will interact with one another. So maybe one of our seniors would be paired with maybe Dr. Isiansa, and then they'll be communicating regularly. And the goal of this is to boost the meaningful engagement of our seniors, and just to, like I said, support give the psychosocial support as well. And that's for the Novi program. The other programs too, that if you go to our website, you get a list of them. And one other thing I'd like to talk about is the partnership bit. I was talking about the AGE Loyalty Network. So the AGE Loyalty Network is a platform where we engage partners from different sectors: transport, health, education, and whatever area it might be, to come up with solutions such that or tailor-made services that will meet the needs of our members. And one of the exciting partnership I'd like to talk about right now, it's M-Pharma. M-Pharma is basically a technology-driven healthcare provider. And what they do is to provide healthcare services, quality healthcare services and medicines at very affordable prices for our members. They partner with health insurance and pharmacies partners as well. And they have a platform called Muti. What the Muti does is it's a model that targets patients who need overall health and in need of overall health and wellness. Now, I've been in touch with a number of our age members who have questions. So hopefully there'll be a session that we are already creating so that we'll have our partners come on board and they'll be able to share exactly what these program is. But the advantage one will get on this Muti platform is that you get a lower market price that's compared to what is out there. You can pay in installments, low delivery costs, and also loyalty-based discounts. So on the whole, the idea is we try to partner with individuals like our lawyers, institutions like SSNIT to make sure that there are solutions, there are services that meet the needs of our seniors and people, or basically age members. One final thing I'd just like to hit to as well, we are building a directory. If you go to the Age website, the directory has a list of organizations and partners we are working with, from people who offer home care services, health services. So if you go to the Age website and you're in need of something, we have a list of institutions there that tailor-make their services for seniors. So you can go through, skim through it and see what sort of service is there and how it can help. Maybe soon we will have our lawyers up there at one point. So basically, Doc, that's what I have. And so if for more information, you can go to our website, like I said, that's ageafrica.com, or you can WhatsApp us or call us and reach out to you. Thank you.
Great. Thank you so much, Caleb. And perhaps you can put the number in the chat box. And for those of you who would love to get in touch with our lawyers, please reach out to us and then we'll put you in touch with them. We don't want to put their numbers out there for security reasons. This is actually on YouTube as well. All right. So we thank God for seeing us through the program and bringing us to an end and getting to this point. It's been very, very fruitful. And for those who feel others would benefit from this, it's on YouTube. We're going to share the YouTube link in the chat. We'll put it on our Age WhatsApp platform as well. If you're not part of us, please, please, please get in touch so that we add you to the Age WhatsApp group. And once we add you, it'll be easier for you to get information on what we're up to and share information on programs like this. So thank you, thank you, thank you. Thank you to our lawyers, God bless you. Thank you to Charles, God bless you. To Israel, who did all the calling and reaching out to people. Prince, Caleb, Philomena, everybody who helped us to put this together, God bless you. And I will leave the chat, I'll leave the link open for a few more minutes so that those who want to copy or want to jot down our numbers from the chat box can do that. I see some messages, private messages coming through as well. And so we'll leave it for a minute and say thank you while we exit. So have a wonderful evening, have a fantastic week. God bless you, God bless you, and God bless you. Thank you. And actually, if I can get people to, let's see who's on there. I usually like to do this at the end so we can see who's online. If you can turn your video on if possible, then we can see you and wave at you. At least we didn't do a hello, but we can do a goodbye. Ah, I see you all. I see Uncle TVO. I see wonderful Auntie Eva. Okay. I see young and old. That's fantastic. That's how it's supposed to be as we learn. So thank you. God bless you. And we'll see you at our next session. Thank you.
Thank you. Bye.
Bye.
I want them to hear my voice. We are really appreciative. This would have cost us a lot of students to pay for. May God bless you.
Thank you.
And give you long life.
Thank you.
Love you. Thank you so much for what you are doing for us.
Thank you, Auntie Eva. Thank you very much. God bless you. Okay, thank you.
Well, it's been a very educative and wonderful program. We are really very, very grateful. Very,
Thank
very
you
grateful.
very much. Thank you. Thank you.
I thought you're putting some numbers up the screen for us.
I will do that. They put the numbers in the chat box, but I can do that. I can put it up on the screen as well, so that you know how to reach us. So let's go live, and I will share my screen. Should add some music. So our numbers are on the screen. This is how you can find us. Oh, Lord. I didn't be prepared. All right, so thank you all. As we end the call, God bless you. And